Good morning. For those of you who are joining us on campus for the first time, or if you don't come here regularly, welcome to Willamette University. I'm delighted to invite you for a fun day of intellectual inquiry where we're going to think about an important public issue here in the state. My name is Tim Johnson. I'm the director of the Center for Governance and Public Policy Research, and I also hold the Grace and Elmer Gowdy Chair in Public Management and Policy Analysis here at the Atkinson Graduate School of Management. It's a real delight to be a part of this event, but my role is going to be a small one. I'm basically going to do one of three things, essentially. First, if you have any needs during the day, I'm going to be the guy who makes sure that you're comfortable so you can focus in on these exciting ideas that will be under discussion. So if something comes up and you need some help, come talk to me. I'll do my best to make sure that you're well situated. The second thing that I'm going to do is to help provide an environment where the folks that we have talking to you today are going to be able to convey the top cutting-edge ideas that are available on the topic of redistricting these days. And one thing that you can do is, if you have any questions for them, I'll be permeating the audience with a microphone, and so you can grab me and I'll provide you the opportunity to speak into the microphone system so you can ask a question. And then the third and final thing that I'm going to do is introduce Stephen Thorsett, our president at Willamette University. In some ways, Steve represents some of the key features of this event. He's a scientist, and so he's the type of guy who appreciates the type of work that Joey Chin has done in recent years to develop rigorous tools to identify gerrymandering and to plan redistricting. But then as well, he's a guy who grew up in our area. He's somebody who was wandering these halls on campus for years in advance of coming back and joining us as our president. And so he also knows about the multi-partisan traditions in our area and the approach that we like to take here in Oregon to think through tough public issues in a civil and constructive way. And so with that, I'd like to introduce you to Steve Thorsett and to kick off these ceremonies today and festivities. Thanks so much.
Thank you, Tim. And I want to offer first my own welcome to all of our many visitors here. Some have come from far away, some from just across the street, but also to welcome the students and the faculty who are here from all over the campus. We have people from all three of our schools, recognizing just what a multidisciplinary challenge redistricting can be. We certainly hope that today's event is going to be a valuable contribution to important conversations that are going on here in Oregon about the integrity and the effectiveness of the legislative redistricting process. But aside from shedding light on a complex issue that affects the state, this event expands on three traditions here at Willamette. First, as Tim mentioned, it expands on Willamette's ongoing commitment to civil nonpartisan discourse around complex policy issues. It's a tradition here at Willamette that we recognize in the model of the late Senator Mark Hatfield, one of the great alumni of this institution. Secondly, this event highlights the role of Willamette's Center for Governance and Public Policy Research in providing a forum for conversations like this in the community. So this center was founded with the belief that the government can benefit from a close and productive relationship between the academic units and the policymaking arms of Oregon. And for 20 years now, the center has provided rigorous interdisciplinary research to all levels of government to aid in decision-making. And then finally, today's event supports Willamette's motto, "Not unto ourselves alone are we born." Here at Willamette, we believe in the sharing of learning and knowledge that connects us together and provides us with an opportunity to improve ourselves and the community around us. So it's our hope that this is what's going to be accomplished by the end of today's session. Now, it is my great regret that I can't personally share this morning with you, but I look forward to hearing about the conversations that take place. And I do have a really important job myself before I go, and that's to introduce today's Master of Ceremonies, Secretary of State Dennis Richardson. Secretary Richardson has a long commitment to public service here in Oregon, having first held elected public office on the Central Point City Council in 2000 and serving 6 terms in the state legislature from 2003 to 2015. Secretary Richardson has served in his current role since January of 2017 and it's my pleasure to invite him to the lectern so he can guide today's program. So please join me in welcoming Secretary Richardson.
It is an honor for me to be here with you to discuss this very, very important issue of redistricting. And I'm grateful for Willamette University to make this opportunity for us to come and discuss this issue, and especially to Director Tim Johnson, who is the Director of Willamette's Center for Governance and Public Policy Research. The goal is to help us anticipate what's coming and not just react to it when it's here. Now, for those that may not know much about redistricting, we have a census every 10 years, and then the year after that, it's an opportunity and a requirement for all states, based on that census, to balance the population in districts. So in Oregon, it means that we have our 30 Senate districts and our 60 House districts, and they're to be balanced in population as much as possible. And then also our congressional districts. Now we have 5 presently, but as Oregon population grows, there's a chance that we actually may get a 6th congressional seat, which is very important. And so redistricting is not always fair. You may have heard a few things about that. There's a term called gerrymandering, right? It's from a governor of Massachusetts who was Governor Jerry back in 1812, and he was the first that's really well known about taking and designing lines that would stack the deck in a certain way to bring about an outcome. Now, in 2016, we had President Obama, who had a comment about redistricting and about gerrymandering. He said, "I think we've got to end the practice of drawing our congressional districts so that politicians can pick their voters and not the other way around. Let a bipartisan group take care of that." Now, that also wasn't new. Back in 1987, President Reagan said, "The fact is, gerrymandering has become a national scandal. The congressional map is a horror show of grotesque, contorted shapes. Districts jump back and forth over mountain ranges, cross large bodies of water, send out their little tentacles to absorb special communities, and ensure safe seats." And so it seems like there's this tendency for those in power to want to retain power at all costs. And yet we have the opportunity coming up to make sure that Oregon is an example of fair redistricting. So a year ago, I was able to help convene a multi-party redistricting reform task force. So we had representatives from all of the various parties in Oregon, as well as non-partisan, non-affiliated voters that came together, and the one common thread that we had was that we wanted to analyze Oregon's situation and then ensure that there are recommendations on how it can be done in a fair and unbiased, nonpartisan manner. So we teamed up in this effort to put power back into the hands of the people and remove the partisan influence of the legislature toward gerrymandering. The purpose of the task force was met over a number of months. We didn't have full unanimity, which you might expect, but we were able to come up with some ideas of common agreement. And we agreed that there is a problem in Oregon, and that if you look back at the district and things that happened in the past, that there is a way to help ensure that redistricting could be appropriate and could be fair. And that would be taking it out of the hands of elected officials. And so here I am, Secretary of State, and historically, there isn't usually an agreement between the House and the Senate and the governor. And so by July 1st, if there's not this agreement, or as happened in 2001, if the governor were to veto what the House and the Senate came up with, then it goes to the Secretary of State.
The Secretary of State has the power then to design the districts as he or she feels is appropriate with public input, and it's got to be turned over by August 15th to the Supreme Court for them to take a look at. So here I am maybe the one who would get that opportunity to be directly involved with redistricting. And I'm suggesting that this would be an ideal time for us to come up with a way that's fair and takes it to the hands of the people and not to the politicians. And so we came up with a number of suggestions that we all agreed on. We felt that there should be a commission of private citizens that do not have a stake in the outcome, that they can't be candidates or future candidates within a period of time. They can't be large donors. They can't be leaders of policy or members of the family of partisan groups or parties. And so the goal was to try and come up with a way, and we used kind of the California model but made it a little bit more Oregon-centric, to have a group of 3 Republicans, actually, it's not that. It's 3 members of the largest registration party, 3 of the second largest registration party, and then 5 individuals from all the other parties and non-affiliated voters. And that this would be selected through the use of auditors who would be also selected to help make sure that these are fair and equitable groups from all over the state. So anyway, we came up with those recommendations, sent it to the legislature, but you may be surprised to know that they didn't act on it. We're not real surprised at that, but we wanted to make sure that if they wanted to consider redistricting in a fair and impartial manner, that we did the initial research. So this is an important issue, and we're here to learn more about it. And so at this point, we will hear from 2 very esteemed speakers and knowledgeable individuals on the legal context of redistricting. So I will introduce to you our 2 speakers. One is Benjamin Gutman. He has served as a Solicitor General for the state of Oregon's Department of Justice since 2016. Prior to assuming that position, Benjamin was the Western Regional Director and Chief Administrative Judge for the Merit System Protection Board from 2011 to 14, and the Deputy Solicitor General for the New York State Office of the Attorney General from 2007 to 2011. He's a graduate of Yale Law School and also received his bachelor's degree in mathematics and philosophy from Yale University. So if you'd like to step up, Benjamin, and I will introduce Phil. Okay, let's welcome him. Okay. So also we'll have Paul Diller come forward, and Paul is a professor here at Willamette University College of Law, and he's directed the law school's Law and Government Certification Program, or Certificate Program, since 2014. Professor Diller's scholarship has focused on the protection of local authority, and he wrote an amicus brief in Gill versus Whitford. It's a recent U.S. Supreme Court case concerning redistricting. So prior to joining Willamette University's College of Law, Professor Diller served as an attorney in the Civil Division of the U.S. Department of Justice in Washington, D.C., and clerked for Chief Justice Edward R. Becker of the U.S. Court of Appeals for the Third Circuit. So it's all welcome, Professor Diller. All right.
Sure. Okay, so first, yes. Good morning. Great to see everybody. Thank you, Secretary Richardson, for the kind introduction. So you're welcome to look at me, and you're also welcome to look over there at the 2 screens, because I have a PowerPoint ready to go here. The format that Ben and I are going to follow is a little bit of ping pong. I'm going to revisit some of the basics about the census and the process of redistricting, elaborating a bit on what Secretary Richardson started to explain a few minutes ago. Then I will hand it over to Ben to talk about some of the U.S. Supreme Court cases that have considered the issue of partisan gerrymandering and whether or not that is unconstitutional, and also other issues that or other factors that may taint gerrymandering or taint districting in the U.S. Supreme Court's eyes. Then we're going to hand it back to me to talk about the amicus brief I worked on that tried to present a particular angle to the U.S. Supreme Court, and that is the effect that gerrymandering, intentional partisan gerrymandering, can have on local government authority by skewing the orientation of a state legislature away from what you might call the median voter of the state. And then we'll hand it back to Ben to talk about, in a little more detail, what other states are doing to create a districting process that is free of gerrymandering. So let's see if this works. There we go. Beautiful. Okay. So the basics of one person, one vote. As Secretary Richardson mentioned, in the Constitution, it is required under Article 1, Section 2, to have a census every 10 years. We're getting ready for the census in 2020. And you may have heard a little bit about that in terms of some of the questions that are going to be asked. And that's, a big part of this process. But the census was originally designed because we needed to know how many people lived in each state in order to allocate representatives. As you know, the Connecticut Compromise at the Constitutional Convention was the Senate. Each state would get 2, and representatives in the U.S. House would be allocated on the basis of population, plus, of course, the infamous 3/5 Compromise for counting slaves in the South. So we needed to know how many people lived in each state for that purpose, and also for electors, since the Electoral College is based on 2 senators plus the number of House representatives. So we need to have this actual enumeration of a state's residents. The Department of Commerce runs the census. It's a big deal. They spend billions of dollars on this, and it's extremely important for all sorts of reasons. So since 1929, the U.S. House, through legislation passed by Congress, has capped its membership at 435. That's not in the Constitution. We could have more. Some people have argued for more, because what's happened is over the years, the average House district with increasing population has increased. So now the average House district size, population-wise, across the country, or at least as of 2010, when the last census was performed, was a little over 710,000. But there's a lot of, there's some variation in that. I was about to say a lot, but I'll say some. The smallest is Rhode Island at 527,000. The largest is Montana. And where you see the most variation is among the small states. And that's because those are the states that are on the cusp of getting 1 or 2. So Montana used to have 2, and then it went down to 1. And it actually has sued, I think 10, 20 years ago, Montana sued the U.S. Census Bureau about the way it went about counting population and allocating districts. But so because they're right on the cusp of having 2, they have the largest. Because Rhode Island is right on the cusp of going down to 1, they have the smallest. The larger the state, the more its district size should approach the median. And so I don't have Oregon's numbers at my fingertips. My guess is they're not too far off from the median, since we have 5 congressional districts. So that's just determining how many representatives a state gets. Okay, what does this state do when it's told, like Oregon, you get 5 representatives? How do you allocate those 5? We take it for granted now that that means 5 districts. It wasn't always that way, if you look at U.S. history. And so until 1964, states had a relatively free hand in designing how their U.S. House districts would look. Many states elected some, or at some points even all, members of their House district at large. That would really cut down on gerrymandering, wouldn't it? If Oregon just elected every state, every U.S. House representative at large. It's actually illegal now. Didn't put that in my slide, but in 1968, I think, Congress banned that for fears that in certain states, especially the South, it would weaken black voting power because you would get, 60% white state would elect all white representatives. So that is now illegal, but for many years it was allowed, and some states did it. And then, of course, before 1964, district populations could vary too. And so here's an example. Georgia, in 1960, after the 1960 census, had one House district of over 800,000 and one of under 300,000. That was the lay of the land before one of the two key one-person, one-vote cases that came to the U.S. Supreme Court in 1964, Westbury versus Sanders. And in that case, the U.S. Supreme Court held that under Article 1, Section 2, House districts within a state had to be equipopulous, at least when they're created after the census. The state can't control if in 2011 it sets up equal districts, and then by 2019 population change is so uneven that they're a little bit off. They're probably not going to be anything like that. But there's going to be some variation. But the idea is by the time the next census rolls around, okay, we'll get back to an even number across districts. And so this refers to this is why every 10 years, Oregon, like every other state, now has to make sure that its congressional districts have equal population, as we will do after the 2020 census, when we might have 6 congressional districts. We'll see. I think we're pretty close. And then they will take effect for the 2022 elections. After Westbury, there was some subsequent litigation about, just how equal do these districts have to be? And the U.S. Supreme Court has been pretty strict. I won't get into all the weeds of the details, but there was one case out of New Jersey, Karcher versus Daggett, where the U.S. Supreme Court wouldn't even allow a variation of less than 1%. So we're talking pretty close to exactly equal districts, or as close as you can reasonably get. So that's really the main mandate now under federal constitutional law, is that the districts be equal. Okay, beyond that, under the federal Constitution, unless and until the U.S. Supreme Court lays out a rule banning partisan gerrymandering, states have a lot of latitude. There is the Voting Rights Act, and I'm not going to talk about that today, but that affects certain states more than others. There are certain states that have to draw certain majority-minority districts. That hasn't been a big consideration in Oregon because of where that law applies. But generally speaking, how the state goes about drawing its districts, so long as it complies with the equal population mandate of Westbury versus Sanders, is up to the state. And so we'll hear more about what states have done. State legislatures. Okay, so the big case that comes along that I'll get to in a minute is Reynolds versus Sims, also in 1964, issued right around the same time as Westbury versus Sanders. That's what some people refer to as the one-person, one-vote revolution, is those two companion cases. But before Reynolds versus Sims, before 1964, there was no federal constitutional mandate for state legislatures to comply with one person, one vote. And so you saw vast variations among states between districts, because many states allocated their districts in their state house or their state senate on the basis of political subdivisions. Just like we, at the federal level, we still do that. We allocate the U.S. Senate on the basis of states. So Wyoming with 600,000 people gets 2 senators. California with 33 million people gets 2 senators. That approach was very common, in states before 1964. So here are some examples. Vermont is a pretty good one. You had a town with a population of 38, and then Burlington had 35,000 people. They each got 1 representative in the Vermont State House. That's a 935 to 1 ratio. Okay. Blows Georgia's U.S. House districts out of the water. And then these are some other disparities going all the way up to 1,414 to 1 in Rhode Island. And so to certain groups at that time, that just struck them as unjust. But the U.S. Supreme Court had never said it violated the Constitution. There was nothing clear from the text saying, you know, all state House districts have to be equal. But there were various interest groups that tried to sue about this, especially those from urban areas, because they felt they were getting the short end of the stick in state legislatures around the country and in U.S. House representation. But what they kept meeting at the Supreme Court was resistance in the form of the political question doctrine. And so in 1946, in a case called Colgrove versus Green, the U.S. Supreme Court, actually in a case attacking congressional districts, but similar to its approach to state legislative districts, says we can't weigh in on this. It's a political question. That's for the political branches to decide, not for us as a Supreme Court. Finally, in 1962, the dam begins to break. And in the historic case of Baker versus Carr out of Tennessee, the U.S. Supreme Court, kind of showing us the writing on the wall, says, no, it's not a political question. It actually is a justiciable question. We will consider the question of whether or not these vast variations in district population violate the Constitution. The two big contenders at that time were the Equal Protection Clause of the 14th Amendment, as well as the Republican Form of Government Clause in the original Constitution. And so those were the two clauses that the plaintiffs were bringing to challenge these vast disparities in state legislatures. And then in Reynolds versus Sims, really one of the watershed cases in U.S. Supreme Court history, which was in challenge to Alabama's legislative districting, which had these kinds of disparities, not nearly as bad as Vermont or Rhode Island, but, you know, still pretty off, 41-1 and 16-1. The U.S. Supreme Court, for the first time, says one person, one vote is part of the 14th Amendment's Equal Protection Clause, and that applies to states, and so state legislatures have to comply with that. This is Chief Justice Earl Warren's famous line, legislators represent people, not trees or acres. Okay, what about the U.S. Senate? Well, that's what Justice Harlan says in his dissent. He says, well, of course, legislators represent trees or acres. But 6-3, the U.S. Supreme Court disagreed. And this was an earth-shattering decision. It caused every state to have to revisit its maps. It actually ended up causing also several states decided to have state constitutional conventions because so much of their constitution, their state constitution, was wrapped up in these inequalities in districting that they said, let's just get back to the table and revisit the whole thing. Oregon didn't do that, but several other states did. For a while, there was actually a lot of resistance to this. I mean, most of us, I think, just take this for granted. Of course, in 2021, Oregon will create equal districts for the 30 Senate seats and the 60 House seats. But there was a lot of resistance to this. I think the Republican Party, in its 1968 platform, called for overturning this decision. There were several prominent judges, law professors who objected to this. Justice Harlan, as I mentioned, he was a prominent objector, very eloquent, to give him his due. If you read his dissents, made a very strong case against this. But ultimately, the decision held and really came to be accepted, I'd say, on a bipartisan basis. In fact, the last time I remember it being an issue was when Justice Alito went up for confirmation to the U.S. Supreme Court, and they unearthed some memos he wrote during his time at the Office of Legal Counsel in the 1980s, where he criticized the one-person, one-vote decisions and said they were an example of judicial activism. And so he was asked about it, even by Republican members of the Senate, and he said, no, that's not what I believe anymore. So I'm not aware of any kind of current movement on the U.S. Supreme Court to revisit this. This is kind of settled as the law of the land. So the implication is states have to redistrict their legislative districts every 10 years, as we will do. Okay, but what about those local political subdivisions, like cities and counties? Okay, if you try to respect their shapes and their borders, that might provide some pressure to deviate from one person, one vote. And so the U.S. Supreme Court has considered this question on multiple occasions, and in one important case, Mahan versus Howell, the court did allow a 16% deviation among districts. They required a justification for it, but they said in certain instances, especially when you're trying to respect political subdivision lines, some deviation is allowed, deviation that high. Anything over 10%, the court is going to look at with some scrutiny, but they will accept some deviation from strict equal population, unlike in the U.S. House context, where 1% was too much. Okay, so there is more deviation allowed. Whether a state wants to do that or not, that's up to the state. Okay, but if it chooses to do that, it might, quote unquote, get away with it from the Supreme Court. And then the other thing I should mention, just because I teach local government law, it's kind of my passion, is the U.S. Supreme Court also then extends one person, one vote down to the local level, which again is something we take for granted but did not used to be the case. So in 1968, the court applies it to county commissions if they're districted. And then in that case, they just assume, of course, the city council would have to have equal population across its districts, like Salem City Council has, I can't remember, 7 or 8, but they all have to be equal in population when we start out after the census. School boards, same thing. Junior college districts, there's this period between 1968 and 1970 where the Supreme Court issues 5, 6, 7 really important one-person, one-vote decisions, all extending it to newer and newer contexts, often local government entities. There is some exception for special purpose districts like irrigation districts. There's an important case called Ball versus James out of Arizona in 1980. But unless you fall into that exception, generally a local government also has to apply or abide by these standards. And at this point, I'll leave it at that and hand it over to Ben.
Great. Well, thank you all for being here, and I'm glad to be participating in this. So, as Paul said, I'm going to just spend a few minutes talking a little bit about the specific issue of partisan gerrymandering and what has happened in the Supreme Court on that. And the question really over the last 30-something years at this point has been, is a claim that a map was drawn to benefit one party over the other, is that something that the courts can get involved with at all? As Paul said, back in the 1960s, we had the same question about the equal population type claims, the one-person, one-vote issue, that with the court first suggesting that it was a non-justiciable political question, just something that the courts categorically shouldn't get involved in, and then finally in the 1960s, the Supreme Court coming around and saying, no, this is a justiciable issue. This is something that there are workable standards for courts to apply in a neutral and fair way. One person, one vote being the standard that it ultimately settled on. And so that is now settled with respect to these issues of population. And the question really has been, can the court do the same thing with respect to claims of partisan gerrymandering, drawing the districts in a way that benefits one party over the other? And so I'm going to talk about essentially 3 cases where the Supreme Court has considered those kinds of claims, and then a little bit about the case that's currently in front of the court out of Wisconsin. So first, the cases from the last 30 years. The first one is a case called Davis versus Bandemere from 1986, and this was an Indiana state legislative map. What essentially happened is after the 1980 census, there was single-party control in Indiana. The Republicans had both houses of the state legislature and the governorship, and they drew a map for the state legislative districts. In the next elections, the Democrats won 52% of the popular vote for the lower house of the state legislature, but only won 43 out of 100 seats. So 52% of the vote only translated into 43 seats. And so they sued and said, this is an unfair partisan gerrymander. Clearly it was done to disadvantage the Democrats. The Supreme Court, the U.S. Supreme Court said, well, that's a justiciable claim. We agree that's the kind of claim that a court can hear. But they couldn't reach an agreement as to what the the standard should be as to how to evaluate that claim. So 4 justices said that what you needed to show was that one party had drawn a map with the intent to benefit that party at the expense of the other party, and that the map in fact actually had that effect and was an unfair map. And what the plurality, the 4 justices said about the Indiana case was, well, we think it's clear that you have the intent here, and pretty much any time that you have a map that's drawn just by one party, we think it's going to be very easy to infer that there was a partisan intent in drawing that map. That's just the way political people behave, is what these justices were saying. But they said that there hadn't been a sufficient showing of an unfair effect on the Democrats in that case, that just looking at the results of a single election, even if they looked anomalous, didn't really tell you anything about whether the map as a whole was fair or unfair to one party or the other. So just the fact that you had 52% of the vote but only got 43% of the seats in one house doesn't tell you much. And the court notes that the Democrats also won for the state Senate seats 53% of the votes and got 54% of the seats in that house. So it does sort of suggest that maybe this was just a one-off anomaly. And at the very least, the court said you can't just look at the results of a single election and say, well, they're disproportionate and therefore that's unfair. So mere proportionality is not the standard here. But that only garnered 4 justices. There were 2 justices who said that they thought that there had been a sufficient showing that this map was unfair. And then there were 3 justices who said that they didn't think that the courts should be involved in deciding these cases at all, that they would treat this as a non-justiciable political question. So you didn't get a majority for any proposition other than the bare proposition that the courts should be hearing these cases. There was 6 to 3 that courts should hear these cases, but no majority for anything else. So no real rule established for the future. The next major case is VF versus Jubeler from 2004, and this was a Pennsylvania case about the Pennsylvania the federal House districts from Pennsylvania. And again, it was a map that had been drawn by a single party in control, and there are not a lot of facts that are recounted in the decision, but it was challenged. The Republicans had controlled both houses of the state legislature and the governorship. The Democrats sued and said this was unfair. And again, the court fractured, and you didn't get a majority to decide anything. You had 4 justices who said, this is just a hopeless enterprise to try to get courts involved in this. There's no workable standard, fair standard, that any court's going to be able to apply in order to determine how much consideration of partisanship is too much consideration of partisanship. And so we think that the courts should just be out of the business of doing this entirely. Then you had 4 justices on the other side who said, no, we think that courts should be able to do this. And in fact, here are some standards that we think the courts should apply. Those 4 justices didn't all agree on what those standards were, but you got essentially 4 different tests as to what the standard that a court might apply to determine whether a map was an unfair partisan gerrymander. And then the deciding vote was Justice Kennedy, who said, well, I agree with the justices who say that we haven't identified a standard yet that we could use, that courts could apply in a fair and neutral way, a workable standard that they could actually apply to separate out these cases. And so I'm going to agree that this case should be dismissed and the courts shouldn't hear this case. But I'm not prepared to say that nobody will ever identify such a standard. And so I would at least hold open the possibility that maybe in the next case somebody will make a better showing and will actually be able to make a presentation to the court that establishes that that a particular map was drawn in a way that a court should strike down because of its partisan bias. Then 2 years later, you had Lulac versus Perry, which was a Texas case. And the unusual feature of this case was that Texas had redrawn its districts in between census, the decennial census. So there had been a map that was drawn in, I guess it was 2000. And then again, in this case, it was also Republicans came into power of both houses of the state legislature and the governorship in, I think it was 2002, and said, we're going to redraw the map because the existing map, we don't like it. The existing map had been drawn by a court, and they thought, well, now that we have a single party in control here, we can redraw the map. And so there's not a lot to say about that case other than, again, the court kind of fractured and didn't really set a clear standard. I think the one thing that it's fair to say that the court didn't agreed was not sufficient is just to say, well, just because you came in the middle of the decade and redrew the maps, that's not enough to show that this is an unfair partisan gerrymander. Even though that's kind of unusual, that wasn't enough. And so all of that finally brings us to the case that's now in front of the Supreme Court, Gill versus Whitford, and this is a case out of Wisconsin. And just briefly, the history in Wisconsin is that in 1990 and in 2000, there was split control of state government both times, and so the political branches were unable to agree on a map for the state legislative districts, and so in both instances, the maps ended up being drawn by courts. They had to redraw the maps because they had to comply with one person, one vote, and you know, the way population moves around and population growth is uneven, they had to redraw them, but the political branches couldn't agree, and so the courts did it. And so then 2010, for the first time in 40 years, the Republicans had gained control of both state houses and the governorship in Wisconsin. And so it was finally an opportunity to draw a map in the sort of the normal way, I guess, which is to have the political branches do that. And so the party went about, I think, what you might imagine a party would do if it was trying to draw a map that was favorable to it. It got all the census data. It developed ways to measure the partisan composition of different districts that it drew. And then it hired some experts and some experts both on the sort of political side in predicting the partisan behavior of voters, and on the computer side in actually drawing maps in different districts. And it just drew tons of maps. And for each one measured what they thought the likely result of elections would be over a wide range of plausible political scenarios in Democratic wave years and Republican wave years, and essentially ended up picking the map that was the most favorable to the Republicans. And I should say, I mean, I think most of this is fairly undisputed in terms of the factual history, but to the extent there is a dispute, what I'm recounting is what the trial court ultimately determined the facts to be here. It essentially took a map that had been roughly a 50-50 map. There were, in a normal year, there would be about 49 of 99 districts would go Republican. So it was roughly a 50-50. And the new map had essentially 60 safe Republican districts. And in fact, that's kind of what the subsequent elections played out. In 2012, the Republicans won 49% of the popular vote statewide and got 60 seats out of 99. In 2014, they improved and they got 52% of the vote, and they got 63 of the 99 seats. And so the Democrats challenged this and said, this is finally a map that is too far, and it should be struck down. Whatever the standard is, it should be struck down. The case was heard by a 3-judge panel on the federal district court. They had a 4-day trial. They brought in all these experts to examine what the actual likely effects of the map were and what the alternatives were. In a split decision, the court ultimately struck down this map and said this map is a partisan gerrymander that violates the Constitution because it just goes too far. And the test that they applied essentially had 3 parts. One is that the map was intended to place a severe impediment on the effectiveness of certain voters because of their political affiliation. So the map was intended to disadvantage, in this case, Democrats. Second, that the map in fact has that effect and is likely to continue to have that effect over the lifetime of this map. And that third, that effect couldn't be justified or explained away by any other neutral criteria, like political geography. And I imagine we'll be hearing more of this today. But there are I mean, it's a phenomena that's not a surprise. Voters tend to cluster to some extent with like-minded voters, and so there can be an advantage to one party or another just based on the political geography of how voters cluster. Democratic voters tend to cluster in urban areas and inner suburbs. Republican voters tend to be spread out more in rural areas and in the suburbs. And so that can benefit one party or another. The majority in this case said there is a natural advantage for Republicans in the political geography of Wisconsin, but it's not nearly large enough to explain the disparity we're seeing. It's like a 2% advantage, and we're looking at something that's here more like a 10 or 12% advantage in the way this map is drawn. And so as I said, the court struck down that map. There was a dissenting judge who said that he thought this was exactly like what going back to the 1986 Indiana case, that all you're complaining about really is a disparity, non-proportionality, disparity between the percentage of the vote that one party got and the number of seats that it got, and that's never been enough. That case was heard by the U.S. Supreme Court in October. We expect a decision by June. The Supreme Court is also considering a case out of Maryland that involves the drawing of a single congressional district that had taken what was essentially a safe Republican district and redrew the boundaries to make it a lean Democrat district. So they have sort of one case where the Democrats are suing and saying this was an unfair gerrymander for Republicans, another slightly different context where you have Republicans suing, saying this was an unfair gerrymander to favor Democrats. We expect them to decide both cases within the next 2 months, and hopefully that will give us some guidance going forward on what the legal standards are, whether there is a standard that the states have to comply with as a matter of constitutional law, and if so, what that standard is. And so now I'm going to turn it back to Paul to.
Is this supposed to end at 10, this panel?
10-10.
10-10. Okay, great. Well, I'll be quick. I was part of a team in Gill versus Whitford that submitted an amicus brief on behalf of several academics who teach local government law, and then also several local government organizations like the International Municipal Lawyers Association, the National League of Cities, and the U.S. Conference of Mayors. And so I'm just going to talk about that particular angle that we put forward in our amicus brief. And that is that another harm of intentional partisan gerrymandering is that it may lead to more preemption of local authority. So many people agree that intentional partisan gerrymandering is not great for democracy because it skews whatever legislation the State House and State Senate are producing. It's producing something that veers from what you might call, and I'm probably messing it up for the political scientists, but what the median voter of the state would like. Okay, you're getting something that skews in a different direction. And that's probably bad from a democratic perspective. But another effect of that is that sometimes this skewed legislation actually takes away local power. So even if local democracy is working okay and is fairly representative, they may be losing power because the state legislature is taking that power away, and the state legislature doesn't really represent what the people are voting for because of gerrymandering. Because of the political geography in many states where you do have a more democratic-leaning urban electorate and a more Republican-leaning rural electorate, that's not the case in every state, but it's the case in many states. This dynamic has really manifested itself in kind of an anti-urban fashion, where you have big cities being preempted by state legislatures that are kind of weighted to represent the rural areas more. And so we just wanted to bring that particular harm to the court's light and went through a whole bunch of different parts of our argument, talked about the importance of local government to our constitutional order. It's something that often gets overlooked because when you look at the U.S. Constitution, it never mentions cities, counties, or local governments. But nonetheless, in various cases, the U.S. Supreme Court has said, oh, but local government is really important because it is closest to the people. They love to cite Alexis de Tocqueville in his 1840s musings on local governments and how great they were and how they epitomized the spirit of democratic America. And so we wanted to kind of set that foundation and then explain this problem about how gerrymandering can hurt local government's ability to work. And one of the main ways you see it happen is preemption, a state coming in and saying, okay, city, you no longer have authority over anti-discrimination, for instance. Okay, but there are other ways as well, and those include denying funding to cities and counties, which we're seeing more and more of on kind of a retaliatory basis. The inability of the disfavored voters to push their policy priorities at the state level. The refusal of the state legislature to reconsider preemption from perhaps pre-gerrymandered days. Okay, so preemption just staying on the books when maybe if you had a more accurately composed legislature, they might say, oh no, let's let local governments handle that. And then that extends down to 4, too, refusal of state legislature to grant home rule, because there are certain states, Oregon has a pretty well-established system of city and county home rule, but some other states do not. So what we did was well, these are some of the states where you see these urban-rural tensions play out. And we looked at 5 states that had efficiency gaps. Did you mention efficiency gap? You did? Okay. You left it for me. Anyway, efficiency gap. Joey can explain it better than we can. But that's the metric the plaintiffs in Gill versus Whitford put forward for measuring intentional partisan gerrymandering. Okay, it's a subject of much debate in the arguments, but it's kind of in my view at least, the best objective metric anyone's come up with yet. Okay, or at least seems like a pretty good one to me, as not a political scientist. And it's designed to kind of measure how many wasted votes a scheme is designed to maximize and how much packing and cracking of voters is going on. And so we just worked off of that and said, let's just work with the plaintiff's metric of the efficiency gap. And we picked these 5 states that had efficiency gaps of over 10% in 2012 or 2014. And those were Florida, Michigan, North Carolina, Ohio, and Wisconsin. So not all of those states where you've seen these significant urban-rural tensions had really high efficiency gaps. Now, it turns out those 5 that had them over 10%, they were all in the Republican direction. I should also mention that another requirement to be in our kind of list of states was that there was other indicia of intentional partisan gerrymandering, like a legislative enacted plan enacted on a partisan basis, or a court finding of intentional partisan gerrymandering, like you had in Florida, actually. These are some of the examples of preemption we've been seeing around the country. If you want to read more about it, check out an issue brief I helped write with some of the other co-authors of the brief. And then we went through the different states and looked at what's been happening there. Florida, see various forms of preemption, especially in 2013, preempting local governments from regulating private workplace benefits and strengthening preemption of local minimum wage ordinances. 2011, penalizing local officials for enacting restrictions on firearms. Michigan, the Death Star bill, okay, preventing cities from regulating any aspect of employment relationships, including minimum wage, leave, and benefits. North Carolina, this one made a lot of news. The bathroom bill passed in 2016. North Carolina is one of the states that appears to have some of the worst intentional gerrymandering since 2010. And so just so happens that's a state where you saw the state legislature step in and preempt its largest city from passing its own anti-discrimination ordinance. And then there was a big outcry, and the legislature walked it back a little bit, but actually this part remains on the books of the bathroom bill, that local governments can't enact higher minimum wages or regulate employment relationships in any way. Ohio, also you see high efficiency gaps and a pretty significant record of preemption and tension between the state legislature and the major cities. And then, of course, we had to include Wisconsin, since that's state whose record is under review in the case. You see some record as well of a weakening of local authority since 2012, and then some that remain from before when the efficiency gaps weren't as bad. I'd have to go back and check. But again, you're not going to get a state legislature to reconsider that if it's been gerrymandered in a particular direction. So that was the angle we wanted to present to the court, and we'll see where it comes down. What I'm hearing is this Benesick case out of Maryland perhaps has muddied the waters, and now people think that the Supreme Court will just punt on the whole thing. But we're just all guessing on that. We'll see. Now I'll hand it back over to Ben, who's going to talk about what other states are doing.
Yeah, and so we also participated in the Wisconsin case. Oregon led a 17-state coalition in submitting arguments to the court, supporting the argument that courts should be involved in policing extreme partisan gerrymanders, that there are workable limits, and that the courts should be policing those. And it's a little bit counterintuitive because you'd think, well, the states are always the ones who get sued over whatever they do, and why would we want to invite more lawsuits against the state? But of course, we also have an interest in good governance, and we also wanted to try to make sure that if the Supreme Court was going to set the courts off to get involved in this area, that they did so under a standard that we states can live with. And one of the things that we did in our arguments to the court was to try to highlight the various things that states have done. They're not required to do it by the Constitution, but things that states have chosen to do that if a state was worried about getting sued would help insulate it from having to litigate these cases about partisan gerrymandering. There are kind of essentially two different approaches states have taken. One is to try to, sort of as a process matter, ensure that the redistricting is not dominated by a single party, and then the other is just in the actual districting process itself to set limits on what information can and can't be considered. And so in the first category, there are 6 states that have delegated the task of redistricting to an independent commission. I think maybe akin to what Secretary Richardson was discussing, a commission on which elected officials can't serve as members. And there are another 6 states that, although they don't have an independent commission like that, have a bipartisan commission. Even in some of the states that don't do one of those things, the legislature in some states has delegated the initial task of drawing the initial map for the legislature to consider to a nonpartisan or bipartisan commission. So then even though the legislature ultimately does have to vote on it and approve it, at least the initial drafting was by a group that was bipartisan or nonpartisan. And then there are a couple of states that sort of do this a different way, which is to require a supermajority vote of the legislature to adopt a redistricting map, with the idea being that although it may be not uncommon for a single party to at least temporarily have control of the state legislature, it would be more unusual for a single party to have supermajority control of both houses of the state legislature. And so with all of these, the idea behind all of them is, of course, that if there is some requirement of buy-in from the 2 major parties, that it makes it a lot harder for a map to be drawn that, at least at the extreme end, is severely benefiting one party over the other. It doesn't necessarily stop gerrymandering. I mean, you still may end up with gerrymandering of other sorts to protect incumbents of both party or to divide up the state in certain ways. But it at least sharply decreases the likelihood that a map was adopted with the intent of really entrenching a single party in power for the long haul against any realistic majoritarian challenge by the voters. So that's one approach that states have taken. And then there are other states, and Oregon is among them, that have state laws that restrict the information that can be used in the districting process. So Oregon, like 8 other states, bars state officials from drawing district lines for the purpose of favoring or disfavoring a political party. I think you then have the question of how that gets enforced, but it's at least the law that's on the books in those states. And then there are a couple of states that prohibit officials from using any kind of political data, such as past election results or voters' registration, party registrations in the districting process. And I think this may be another area where, I mean, we'll be talking a little bit about some of the technology, and it can be a curse and a benefit. I mean, on the one hand, it's become much easier to engage in kind of the most extreme partisan gerrymandering because we have, in the era of big data, we have a lot more information about voters and what voters are likely to do. And we also have the computing power to draw thousands or tens of thousands or millions of maps that alter boundaries in subtle ways and make predictions. So, back in 1812 when Governor Elbridge Gerry was gerrymandering in Massachusetts, I mean, you needed like a 60-40 split or worse to actually have a safe seat for a party. These days, with the data that we have and the tools that we have to draw maps, you can draw, sort of 52-48 seats and really kind of pack and crack your opponent's voters more efficiently. But I think at the same time, you have at least the potential to use that technology to do the reverse. Because if you have a state that says that you simply can't use certain kind of data, presumably, I'm not a computer person, but presumably you can tell the computer not to consider that kind of data. And you can see what the computer was actually asked to do. And so I think there's at least the potential for some promise for laws like this that limit the inputs that can go into the districting process to restrain the results. And as I said, I mean, our view, as a state presenting this to the Supreme Court, was that a state's not required to do any of these things, but that these are tools that are available. And they show that states are experimenting with different ways to reduce or even eliminate the extreme partisan gerrymanders. And so, yes, I want to go to questions.
Yeah. So I'm curious whether there was any argument made in the Gilby-Whitford or whether anybody considered the issue of the increasing non-affiliation of voters. As you know, in Oregon now, non-affiliated voters are the plurality. They are larger than either party. And when you have only a bipartisan commission and you're only worried about Democrats or Republicans, you've really effectively disenfranchised a plurality of voters in some states like Oregon. I think Washington and California are pretty similar. What was Secretary Richardson's idea of a 6-5 commission actually is a great idea for that reason. It seems to me that that's obviously.
Well, I think the short answer is there's been very little attention to that in Gill, and in fact, I think in most of the cases that I've seen, and I think it is very important. Now, my understanding, and again, I'm not the political scientist here, so maybe you should be directing this to other people, is that a lot of these models of voter behavior that we're looking at do account for the fact that we have people who are not registered Democratic or Republican, but still may exhibit a certain pattern of how they vote, or you can make predictions about how they'll vote and how they'll vote. Again, they're typically looking at a range of electoral possibilities. So if we have, again, like a wave Democratic year, what would that mean in terms of the actual on-the-ground behavior of particular voters and including unaffiliated voters? So I think it's being taken into account on the predictive end. I don't think there's been a lot of effort to take that into account in terms of the legal doctrine and whether that should play a role in the court deciding what is or isn't appropriate. So it's an excellent question, and I think it deserves more explanation.
Some states talk about prohibitions from using certain kinds of data. You can think of it political either registration or turnout or actual votes. But what about proxies, things that may not be coming from a political party, not a voting registration? Something like car registration. And people have talked about doing one for psychographics and marketing, that certain cars have certain kinds of profiles of ownership. I had a neighbor, who had both a Hummer and a Prius in the driveway.
That's an unaffiliated voter. No, that's an excellent point, and I think it maybe suggests one of the limits of this kind of approach is that, and this is true probably in any legal regime, people find the loopholes and find the ways around that, and if you ban consideration of a particular variable directly, people will find good proxies for it. So I think that's, I mean, I don't know of any state that is considering trying to ban sort of more proxies for voter behavior as opposed to just consideration of the direct evidence. But I think it's a good point that that would be a limitation. As I say, as far as I know, there are only 2 states that directly ban consideration of registration data or past election results.
Have you had a chance to see the other amicus briefs that were filed, to see if any of them input the proxies?
I don't. There were a lot of amicus briefs, and at least the ones that I have read, I did not see any that discuss that. I don't know if you did,
Well,
Paul.
but what your comment brings to mind is Florida passed a state constitutional amendment that bans the use of political considerations for districting. And so your question raises the issue of would using proxy data
Yeah.
be like, disparate impact,
Yeah.
right, in federal constitutional law?
More question?
So my guess is in Florida, for instance, the courts would say you're violating the provision by doing that.
One more question?
Could you confirm that the efficiency gap analysis does not use voter registration data?
The efficiency, again, this is not my field, but I think when you're looking at the results of a past election, you're looking for the votes that were actually cast,
Right.
not the affiliation of the voters. So if if somebody who's registered as a Republican votes for the Democratic candidate, that's a Democratic vote in that. So one of the nice things I think about the efficiency gap as a metric is that you're not making predictions about what voter behavior will be. You're actually looking at what voters have done in a particular election. And if the vote was 80% for the Democratic candidate and 20% for the Republican candidate in a particular district, you can say, well, 30% of the Democratic votes were wasted because that was more than what you needed to elect that candidate. 20% of the Republican, vote was wasted for a Republican. There's a 10% gap there. That's how efficiency gap works.
My most important question on efficiency gap is whether Nick Stephanopoulos is related to George Stephanopoulos.
I don't know the answer to that.
Are they spelled the same? I don't know. Okay.
Ancestry.com.
Yeah.
Oh, you would know that, Dennis.
All right. Thank you, everybody. Appreciate it. Thanks. Thank you. This is a great discussion, isn't it? One of the points that was brought up was, the need for Republican and Democrats and non-affiliated voters to all buy in to whatever the process is or whatever the maps are going to be. And one of the things that our task force was recommending was, you have 3 from the largest registered party, 3 from the next largest, and then 5 others. So you got 11. But to have a decision, it would require 7 votes and at least 1 from each of the 3 groups, so that you couldn't just have, the swing votes become very popular as everybody's trying to politic to get those votes. Anyway, let's take a break. We'll come back at 10:25. All right? Thank you, everybody.